Determinative conferences and hearings are legal processes. They rely on applicants and respondents presenting their evidence and arguments before a commission member can make a binding decision about whether a dismissal was fair or unfair. Your evidence and arguments must first be presented in written form. The Commission has templates to help you prepare these documents. These documents must be completed well in advance of the hearing or conference.
Very important to have filed those on time, because the tribunal member will have had an opportunity to read them before coming into the determinative conference, and so has an idea then about, well, what are the real issues in dispute? What are the matters that the tribunal member needs to decide upon?
You will also have the opportunity to tell the Commission member about your evidence and arguments at your conference or hearing. So don't worry if you find writing your documents difficult, just complete them as best you can. There are 3 important documents that should be completed before a determinative conference or hearing. The former employee, called the applicant, and the former employer, called the respondent, both complete these forms. The forms are a document list, statements of evidence, sometimes referred to as witness statements, and an outline of arguments about the merits of your case. Templates for these documents will be sent to you by the Commission, or you can download them from our website. The document list is an important summary of all the documents you will be presenting and relying on for your case. This could include an employment contract, emails, medical certificates, warning letters, pay slips, or any other documents that support your argument. This list helps organise everything so nothing is overlooked. A statement of evidence is required from every person who wants to tell the Commission about something that happened. People often call these witness statements. The dismissed worker and their former employer should always provide a statement of evidence, but often there will be other witnesses who also wish to give evidence. They must also prepare their own statement of evidence.
What we want to know is what happened. We want to know what they saw. We want to know what they heard. So it's very important, both in their written statement and also in their oral evidence, that they talk about only their own experience of what they saw, of what they heard.
Statements can be written in longhand paragraphs or as a bullet point list. Numbering each paragraph or point in the statement can make it easier for everyone to locate information during the hearing or conference. Witnesses who provide statements must attend the determinative conference or hearing so that their evidence can be tested through questioning and cross-examination.
If they don't attend the Commission and they don't provide the other side with an opportunity to put contrary allegations to them or to test their evidence, that's unfair on the person against whom the allegations is being made. And so in those circumstances, more often than not, we can't rely upon that evidence.
In your outline of arguments, merits, you set out all the facts you think the Commission member needs to decide if the dismissal was fair or unfair. The form provides guides on what information you should consider in each section. There is more information on our website if you need further help completing this document. You'll need to include employment details, including pay, information about any misconduct or work performance issues, details about the dismissal, including how and why it happened, and the applicant, who is the dismissed worker, should identify the remedy they are seeking from the Commission. If a dismissal is found to be fair, the application is dismissed and the matter is over. But if the dismissal is found to be unfair, the Commission can issue orders for a remedy. Under the Fair Work Act, the Commission can order 2 remedies. First, it can order that a dismissed worker be reinstated to their job, if appropriate. The second remedy is payment of compensation. Compensation is capped by the Fair Work Act. More information about compensation can be found on the Commission's website. There is a final document that will only be necessary in some instances. It's called the Outline of Arguments, Objections. It's only required when the former employer is raising an objection to the Commission dealing with the matter because it is outside the Commission's jurisdiction. If that's happened, both parties must lodge an outline of why they believe the objection should or should not be upheld. Some jurisdictional objections are dealt with before the Commission considers whether the dismissal was fair or unfair. But other jurisdictional objections are dealt with at the same time as the determinative conference or hearing to hear the substantive matter, that is, why the parties believe the dismissal was fair or unfair. For more information about jurisdictional objections, follow the links on the page you are on now. Once complete, copies of your documents must be provided to the Commission and the other party. This has to be done well in advance of your matter being heard. You should also bring all of the documents with you, including copies for the member and the other side when you come to your hearing or determinative conference. For more information on preparing for hearings and conferences, follow the link on the page you're on now.